Today we will discuss next topic, that is general meeting. The word general meeting is basically made by the combination of two words. One is general. General means common for all, open for all, open category. Like general category OBC, SC, ST. So general means open for all. Meeting. Meeting means when two or more persons sit together and they discuss on some issue is known as meeting. And in administration of the company, many meetings take place. The meetings of directors, okay, etc. But every meeting is not open for all shareholders. A meeting that is open for every members, every shareholder is known as general meeting. Okay. Now there are two types of general meeting. One is annual general meeting and another is extraordinary general meeting. Annual general meeting is known as, in its abbreviated form, AGM, and extraordinary general meeting is EGM. Now, as the name suggests, that annual general meeting means that general meeting that convene at every year. So first we will discuss that what is annual general meeting, what are the requirements, and then we will discuss extraordinary general meeting, and after that all other issues related to both annual general meeting and extraordinary general meeting. See, annual general meeting and the provisions related to annual general meeting are in section 96 of the Companies Act. Annual general meeting means that meeting which is open for all members or shareholders and convened every year is known as the annual general meeting. Now, when we see that why this is convened every year, because section 96 subsection 1 mandate that general meeting that has to be convened every year would known as the annual general meeting. And at the meeting, the CEO, director, they typically speak on the company's present status, its annual report, audited account which contain information for the shareholder about its performance, its future strategy, etc. Shareholder with voting right vote on issues such as appointment of company's board of director, auditors for new accounting terms, executive compensation, payment of the dividend, and the shareholder who do not attend the meeting maybe vote through proxy also, through the proxy also they can be attend the meeting. Now, on the annual general meeting, when we see section 96 subsection 1, that every company other than one person company shall in each year hold, in addition to other meeting, a general meeting as its annual general meeting. So here section 96 subsection 1 define the general meeting, also mandate that it has to be convened in every year, but this provision is not applicable for the one पर्सन कंपनी. वन पर्सन कंपनी में तो वो सिंगल पर्सन है, वो किसके साथ डिस्कस करेगा, क्या मीटिंग होगी उसकी. ओके, देन एंड शैल स्पेसिफाई द मीटिंग as such in the notices calling it, and not more than 15 months shall elapse between the date of one annual general meeting of the company and that of the next. So every year a general meeting has to be convened, and between two general meeting there should not be gap more than 15 month, half quarter and half year, should not be more than. Suppose in 2021 a person, a company has convened the meeting in January 2021. So it's not that in the 22 also a meeting has to be convened. So if company convene the meeting in the 22 December of 22, in the December month. So this is between the two meetings, meeting convened in 2021 and meeting convened in 2022, the gap also has to be seen, so that to make it functional. Okay. Otherwise, the very purpose will be defeated. The purpose is that the shareholders have the ultimate control. They have invested the money, but the major decisions are taken by the directors. So they must review. So first, quickly we discuss that purpose of this annual general meeting. It is an opportunity for the shareholder to receive the company's account as well as reviewing the fiscal information for the past year. And the activist shareholder use this annual general meeting as an opportunity to express their concern by asking questions regarding the direction of the business that took place or that will took place in the future. Thus, the annual general meeting is very important institutions for the protections of the interest of shareholder. The ultimate control and the destiny of the company should be in hands of the shareholder. They must also see that the money they have invested, how that has to be has been used or will use in the future. So that is the purpose. And to see, and with that purpose, every year one meeting has to be convened, that is open for all shareholder. But sometimes the business community in this also, very you can say cleverly, they put the meeting that the time between the meeting exceeded up to the 2 year. If the first meeting in 2021 in January and in the 2022 again the meeting has to be convened, but they are convening in December. Now if you see the time gap between them, it's around 22 months, and just to avoid this they have put that the general meeting has to be convened, at least one general meeting has to be convened in every year, and between two general meeting, that means to the consecutive years, there should not be gap more than the 15 months. Now there are three proviso attached to the section 96 subsection 1, that what about the first annual general meeting when the company is just incorporated. Suppose the company is incorporated in February. So in that case, when or if the company is incorporated in December itself, so in that case it's very difficult if you saying that December में company incorporate हो, December के December में आप meeting करो, because every year one meeting has to be convened. Suppose the company incorporated on 31st or on the 30th December, so it's not possible to convene meeting in that particular year. And so the proviso says that in case the first annual general meeting, it shall be held within the period of 9 months from the date of closing of first financial year of the company. The financial year of the company, from that date within the 9th month it has to be convened, and in any case within the 6 months from the date of closing of financial year. So this first financial year is talking about the company's financial year, and the second is about the general financial year. Provided further that if company hold its first annual general meeting aforesaid, it shall not be necessary for the company to hold any annual general meeting in the year of its incorporation. If this meeting is done, then it's not necessary to have the annual general meeting. Now this thing or this provision you apply, suppose the company was incorporated on 30th December you know, 2021. So in 21 it's not mandatory to have the meeting. So this proviso is just you know, as a way of exceptions to the subsection 1. Now we have said that this is the meeting open for shareholders, and in the meeting we have discussed that in the meeting people gather together and discuss some issue. But how the shareholders will come to know that there is a meeting? Because if there is no such notice, then one cannot expect that the shareholders will have the knowledge or will attend the meeting. The second thing, that the meeting should be convened at first a you know, at a reasonable time, not on the national holiday. Suppose some company has registered, suppose convene the meeting on the 26th January, the shareholders may not be able to attend. And so what is the time and date that is used for this annual general meeting? With the purpose so that the shareholders who wanted to attend this general meeting can attend. And with this purpose, there is section 96 subsection 2, that every general meeting shall be called during the business hours. What is business hours? From morning 9 a.m. to the 6 p.m. It is written here, what I am saying. From 9 a.m. to 6 p.m. on any day, and that day should not be national holiday, and shall be held either at the registered office or at some other place within the city, town or village in which the registered office of the company is situated. So the place, it should be at the registered office, but suppose it's not convenient, it's not physical possible to convene meeting because large number of the shareholder or some other problem. So in that case, within that city at some other place this meeting can be convened, but not your company have registered office in Delhi and you are convening the meeting like the Simla Samjhota in Simla. वहाँ कौन जाएगा? Second, it must be within the business hour. So an expected shareholder can attend between 9 a.m. to 6 p.m. It's not like you are convening the meeting at the night. And third is that it should not be on the national holiday. Okay. Then proviso that provided that annual general meeting of an unlisted company may be held at any place in India if consent is given in writing. So with the consent, if there is unlisted company, so listed means that is listed in the share market, and listed without you know, the share market, listed in the share market. So that unlisted company, for that if the shareholder through electronic you know, they have given the consent ki in advance ki ye convene ho sakti, so in that way also it can be done. Now the this is the general requirement. Now before that the notice has to be given. Suppose the company want to convene meeting on the like 22nd February, and they are giving the notice, or the shareholder getting the mail on the 20th or 21st February regarding this mail. So it would not be advisable. So there must be some period has to be given, so that every shareholder must manage its affair and make it possible to attend the meeting. Otherwise, what would be the very purpose? And so section 101 talk about the notice of meeting. It says that a general meeting of the company may be called by giving not less than 21 days notice, either in writing or through the electronic mode, in such manner as may be prescribed. So maybe through the registered email, if the shareholder has given through the electronic, any electronic mode, like you know, the mail, or it may be WhatsApp message, whatever be, electronic mode word is used, so that is convenient. इन एनी वे वो मेल है या उनका और कुछ भी जो भी पर्पज़ है उसके थ्रू वो दे सकते हैं, और राइटिंग में भी. but there must be gap of 21 days. 21 days. And this provision is again with the purpose to make the meeting effective. If the shareholders will not participate in the meeting, then what is the what was the purpose for which this provision is enacted would not be served. So the shareholders can arrange their affairs, they can manage and attend the meeting. Then section 101 subsection 2, every notice of the company shall specify the place, सपोज रजिस्टर्ड ऑफिस है तो रजिस्टर्ड ऑफिस, या उसी में कोई टाउन हॉल या और कोई बैंक्वेट हॉल हो तो उसका प्लेस, डेट एग्जैक्टली like on the 21st February 2022, the day, what would be the day on that particular time, like the Friday, the hour is the section 96 subsection 2 only talk about that meeting has to be convened between the business hour, but it may be from 9 to 12, it may be from 12 to 3 p.m., it may be from 3 to 6, so that hour also has to be mentioned in the meeting. Now the most important thing, when someone inviting you for the meeting and they have not tell you that what is the issue that would be discussed, okay, what is the things that would be discussed, that means the agenda is not put. So you will take part in the meeting, but you cannot make the wise participation in the discussion. Your wisdom, you cannot show your wisdom because you are unaware about the agenda. And so the statement should also be there कि meeting में होगा क्या. You were thinking about something else or an agenda, there was other things, that for that you have not prepared, you have not done research, you have not well acquainted with the facts, and so this type of the things would also not serve the purpose. And so in section 101 subsection 2, after this date, time, and shall contain a statement of the business to be transacted at such meeting. Then section 101 subsection 3, the notice of every meeting of the company shall be given to every member of the company, legal representative of the deceased member or assignee of an insolvent member, auditor and auditors of the company, every director of the company. And then section 101 subsection 4, that if there is an accidental omission or if someone has not received the notice, suppose you have blocked that particular mail of the company, or by any other reason you accidentally you have not received the notice, then such notice for any meeting shall not invalidate the proceeding of the meeting. So just it is to avoiding the inadvertent circumstances in which accidentally if some person is missed, but this provision must not be used to defeat the very purpose by which section 101 and section 96 is drafted. Now there is mandate in the section 96 subsection 1, but what would be the consequence if company does not convene the meeting? Okay, because if there is no consequence, then the compliance of the provision cannot be expected. It is not guarantee that the provision will be complied if there is no consequence, like John Austin has defined in the positive school of law, that law is the command of sovereign. The people obeys and there is the fear of sanction. So if the meeting has not been convened, or if there is not the gap between two meetings of the 15 month, so what is the consequence? And the consequence is that the first is the members can make the application to the tribunal that this happened, meeting has not been convened, and then the tribunal will convene the meeting. The second is the punishment in default will the complying, and for that there is a punishment also. So these are the twofold consequence, even if there is the punishment, if there is only the penalty, but there is no way of convening the meeting, then also the whole purpose would not be served. Okay. And so section 96, power of the tribunal to call annual general meeting. If any default is made in holding the annual general meeting of the company under section 96, the tribunal may, notwithstanding anything contained in this act or the article of the company or on the application of any member of the company. So, any member, it is not saying how many members or director, any member of the company may make an application before the tribunal, and that this particular year a general meeting has not been convened, and then call or direct the calling of an annual general meeting of the company and give such ancillary and consequential directions as the tribunal thing. And after making the application to the tribunal may call the meeting. Okay. Now section 97 subsection 2, a annual general meeting held in pursuance of subsection 1, when the tribunal call for the general meeting because the annual general meeting has not been convened. Okay. So maybe suppose in 1921 shareholder are expected कि जनरल मीटिंग होगी जनवरी से दिसंबर निकाल दिया, और फिर इन्होंने दिसंबर में जब मीटिंग नहीं हुई तो इन्होंने 30 दिसंबर को कहा भाई अब तो एक दिन बच गया, अब तो एप्लीकेशन लगानी पड़ेगी. सो द वन ऑफ द एक्टिविस्ट शेयर होल्डर हैज पुट एप्लीकेशन बिफोर द ट्राइब्यूनल. अब ट्राइब्यूनल भी 1-2-4 दिन का टाइम लेगा, एंड दे हैव डिसाइडेड देन कम टू द नेक्स्ट ईयर 22, एंड इन द 22 देन द ट्राइब्यूनल डायरेक्टेड फॉर होल्डिंग द जनरल मीटिंग. अब ये 22 में जो जनरल मीटिंग होगी इसका स्टेटस क्या होगा? And so section 97 subsection 2 is making that. Actually it is not holding in the period of 1921. So here factually it is not in 1921, but there is the deeming provision, legal fiction, that a general meeting held in pursuance of subsection 1 shall, subject to any direction of the tribunal, be deemed to be annual general meeting of the company under this act. So this would be called as the annual general meeting, first thing. And the second thing, in the ये जिस ईयर की होगी उस ईयर की ये जनरल मीटिंग आपको होगी. नाउ कम टू द next is the punishment. Section 99, if any default is made, the marginal note first I read, punishment for default in complying with provision of section 96 and 98. If any default is made in holding meeting of the company in accordance with section 96, 97, 98 or in complying with any direction of the tribunal. Any direction means that in 96 subsection 1 that any ancillary or consequential, वो ट्राइब्यूनल जो है मीटिंग कन्वीन का ऑर्डर करके उसके साथ भी कुछ डायरेक्शन दे सकता है. सो इफ दैट डायरेक्शन the company and every officer of the company who is in default shall be punishable with fine which may extend to 1 lakh rupees. And in case of continuing default means suppose the date is mentioned like the 15th of March you have to convene the meeting, and after that you are making the default. So every day with the default, further fine which may extend to 5,000 rupees for every day during which the default continue. Now there are some cases on this point, that failure to call the meeting which is generally in pursuance of order of the tribunal is an offence, as we have discussed, and the penalty is imposed on the company as well as on every officer who is in default. Now which is the person who is in default? There is, just give me 1 second, officer who is in default. Section 260 when you read section 260, officer who is in default, here it is defined officer who is in default for the purpose of this act. So those persons, like the person who is in default would be helpful to find out the exact person who will be responsible. Now there is this case Sri Meenakshi Mills Company Limited versus Registrar of Joint Stock Companies. You can find this case in Avatar Singh book also. And here a company was prosecuted because the company has not convened the meeting. How? In the year 1934 December, the general meeting was called, and this general meeting was, in the meeting the quorum has to be fulfilled. अगर जनरल मीटिंग आपने बुलाई है तो कुछ quorum तो होगा ना. Quorum is the minimum number, the threshold number of the person that is required for making any valid decision. Okay, so that quorum was, suppose the quorum has not been, okay Abhishek, I will raise your question also. If the quorum has not been met or there is any other issue, so the adjourned. So the meeting was adjourned, and this adjourned meeting then held in the next year in 1935. Then in 1935 no other meeting was held. Then in 1936, annual general meeting happened, and on that the one person has made the application that in 1935 the meeting was not held. What was held was only the adjourned meeting of the 1934, and so the company made the default of the section 96. So as per the section 99, the prosecutions, the fine, etc. And the prosecution was started, the fine was imposed, but the court held that meeting of March was adjourned meeting, and there should be one meeting per year, as may be as many meeting as there are, and the company accordingly convicted. So if there is any adjourned meeting of the past year, that would not be concerned as the annual general meeting. Annual general meeting means the fresh general meeting. So this case is very important, that maybe it looks that in 1935 also the meeting happened, but the meeting, annual general meeting means the fresh annual general meeting. Okay? Yes Abhishek, now I will take your question.
सर ये जो कोरम होती है ये सर सिर्फ डायरेक्टर्स ही कॉन्स्टिट्यूट करते हैं ना इसको, और तो सर कोई नहीं होता कि शेयर होल्डर्स भी होते हैं इसमें?
इसमें तो सारा सब लोगों के लिए ओपन है. एनुअल जनरल मीटिंग एंड एक्स्ट्रा ऑर्डिनरी जनरल मीटिंग इज
नहीं
ओपन
सर, जो
फॉर ऑल.
सर जो कोरम होती है,
Quorum means
कोरम
the minimum number. Minimum numbers means the persons who are eligible to attend, the meeting. So all those persons, a minimum number is fixed. That provisions also we will discuss, that what would be that minimum number. So यहाँ पे as a director, as a shareholder, general shareholder also, you are on the same footing. वो मिनिमम नंबर देखा जाएगा सारों का ही, वो कंबाइन हो या कैसे भी हो. सपोज समझ गए, वो सारे लोग
जी
सेम पोजीशन पे है, उसके अकॉर्डिंग होगा. नाउ देर इज here in the section 99, when you see here, it's saying that if any default is made, so ये default किस तरह का होना होगा, whether it is only the willful default or it is the default of any kind. Here one case I have to discuss, that in Kastur Mal Banthia versus State, the meeting was not convened, and when there was the conviction, suppose under section 99 of the Companies Act, the facts were produced that the accused and his brother were only two members and the director of the private company, because it is applies to the every company except one person company. So there were only 2 members, and during the period when the meeting should have been held, his brother was lying seriously ill. So one of the brother was ill, suppose cancer से पीड़ित है या किसी भी तरह से है, not able to attend, and consequent the failure to hold the meeting was not considered to be the willful default. Okay. So here also, though in section 99 we the word used is the default, but that default must be willful default. If we interpret this default by any means or default with any reasons, then it would be miscarriage of justice. Like in this case there were only 2 members, एक भाई पूरी तरह से बीमार है, so you cannot expect to convene the meeting in that particular case. And then where the meeting, where a managing director has been pressing his colleague to call the annual meeting but in vain, he could not for the purposes of this section be described as officer in default. Here the other word used is the who will be liable, the company, and the person is in default. Now when in the this case also you can write if you want to, SS Jhunjhunwala versus State 1970, SS Jhunjhunwala. In that case, when the conviction, when the the prosecution started under section 99, तो उससे पहले तो 1956 का एक्ट था, but as per our new. So he says that I was not in the default, but because many time as the managing director I pressed the colleagues to call the annual journal meeting, but because I am only one person, so I cannot force that much. And but there are the evidences that proved that he wrote many mails, etc. And in that case, that person cannot be, that the person who is in default, the officer is in the default. So the person was not convicted because the the punishment is the company and the person who is in default. So the company also, the default means the willful default we have discussed in the Kastur Mal Bhatia versus State, and the person who is in default means that that there must be something that shows the person's default. If the person actively did something for convening the meeting, like the managing director has pressed, he wrote many mails, in that case we cannot say that he was in the default because he did his duty. Now come to the after this, suppose notice भी आपका हो गया, 21 दिन का, लोग भी डिसाइड, समय भी डिसाइड हो गया. Now section 102, that the statement to be annexed with the notice. Here minutely the facts concerning the special business and item of the special business transacted in the general meeting shall be annexed. So here along with section 101, this section also you have to read, talking about the agenda. Then suppose the meeting was convened on the 22nd February 2021, day is also decided, time is also from 12 to 3 p.m. When meeting will start? Meeting has to start, it's not only one person has come and he will make the binding decision. For every forum, a minimum number is required for making the valid decision, and that is known as quorum. So section 103, as Abhishek also asked, the quorum of the meeting. And here section 103 subsection 1 says that unless the article of the company provide for the larger quorum. Suppose in the articles of the association with respect to the quorum there is provision that how many members, how many persons will make the quorum in the general meeting. So that would apply if there is no quorum mentioned in the annual general, in the articles of the association. In case if a public company, 5 member present, only 5 member is required, if the number of member on the date of meeting is not more than 1000. So if the company has less than 1000 members, if 5 members came, the quorum is complete, they can make the decision, they can start the discussion, pass the resolution. 15 members personally present if the number of members as on the date of meeting is more than 1000 but up to 5000, and 30 members when the number of members more than 30,000. This is about public company. In private, 2 member personally present shall be the quorum of the meeting, whatever be the number of the in the private company for the quorum 2 person. But when this quorum has to be needed, suppose the meeting was put at the 12, कब तक वेट करें इन 5 लोगों का, 10 लोगों का, 15 लोगों का? हाफ आवर. Section 103 subsection 2, if the quorum is not present within the half hour from the time, so this quorum has to be maintained in within half hours, and if that quorum is not fulfilled, then meeting would be adjourned. So section 103 subsection 2a, that meeting shall stand adjourned on the same day and the next week. Okay. Now come to uh, the next, that that if the meeting is there, there must be some person who chair the meeting, otherwise it would be in the very like hodgepodge. So the chairman, how the chairman will be elected? Section 104, that if unless the article of the company otherwise provide, the member personally present in the meeting shall elect. So in every meeting, person will elect the chairmen, and chairman will put the agenda. On every agenda there would be discussion. After the discussion, the resolution, if anything has to be passed, that would be passed. In case of the proxy, suppose like the if a council is not able to present before the court, he sent his proxy. So here also proxy can be sent. Proxy will not speak, but can make vote unless there is the poll. Only in the poll he can vote. If the voting is through the hands, that he will not do. Now come to the second, the extraordinary general meeting. See, as the name suggests, the extraordinary general meeting, that means it is other than the annual general meeting. Whenever there is something urgent is necessary, there is something urgent is required. And clause 42, clause 42, table F, schedule 1. When you read clause 42, table F, schedule 1, there the general meeting, all general meeting other than annual general meeting shall be called extraordinary general meeting. So it defines very clearly that any general meeting, if in a year one general meeting is happened, then the other general meeting will be extraordinary general meeting, because the company will not convene, will not take the pain even after one general meeting to have again that general meeting, because it's so complex. You have to give the notices 21st days before, then you have to arrange the place. All these things has to be very important. And the provisions related to extraordinary general meetings are in
Sir,
section 100. Yes.
sir, could you please repeat the clause number of table F?
Clause 42, table F, schedule 1. Okay, Milan.
जी sir.
Okay, then section 100, that talking about extraordinary general meeting. The board may, whenever it deems fit, call an extraordinary general meeting. So basically the power is with the board of director. The board of director, if they fit, it's different from section 96 where it is mandatory to call the annual general meeting in every year. Here if the board of director they require, they can call, provided that an extraordinary general meeting of the company other than the wholly owned subsidiary company incorporated outside shall be held at a place within the India. Okay, so it may be held, at other places also. There is no requirement there under section 96, that requirement you will not find. And then board shall at the requisition made, then in the subsection 2, two clauses are there: call an extraordinary meeting of the company within the period specified in the subsection 4, when, in case the company having the share capital, the number of member who hold on the date of the recipient of requisition not less than 1/10 of the such paid up share capital of the company as on the date carries the right of voting. In case of company not having the share capital, the number who have been at the date of recipient of requisition not less than 1/10 of the total voting. So at in that case also the company make the meeting. Then other provisions you will find with respect to in this, you have to read in the section 100. Now the quorum, as I have said, that quorum is applicable both general meeting, ordinary, that annual general meeting, as well as the extraordinary general meeting. Now how the voting will be done? The voting will be done by the hand, even if it is the choosing of the that chairman or otherwise. Section 107 says that voting by shows of hand. Any general meeting, a resolution put on the vote of the meeting unless a poll is demanded under section 109, voting is carried out electronically, be decided to show of vote. So unless under section 109 when poll is done, then otherwise the voting would be by showing the hand. If that is not not sufficient, that in case voting will be done in the demand of poll. So for that section 108 and 9 you can read. Now after the quorum is completed, the person has chairman also, agenda उसमें रखा हुआ था, agenda discuss हुआ, and then suppose the agenda is for passing some changes in the company or other things, so that the resolution has to be passed, and there the resolution would be ordinary resolution or the special resolution. For the ordinary resolution, a resolution shall be ordinary resolution if notice required under this act has been duly given. Section 114 you have to read with respect to ordinary and the special resolution. And I think earlier also we have discussed. So you discuss that in case of ordinary resolutions, how the vote has to be what vote number of votes required. In case of special resolution, subsection 2 of the section 14, that number of votes, if any, in against the resolution, then the number of vote in favor must be 3 times the number of vote against the resolution. So I am just quick, because I have want to complete this topic. Only one thing is left, that after suppose resolution भी pass हो गया, अब मीटिंग आपकी खत्म हो गई, then preparation of minutes. The law faculty also, when the meetings happened, we make the minutes. Okay, minutes is prepared कि क्या डिस्कस हुआ, क्या क्या उसमें हुआ, और फाइनली क्या कंक्लूजन लिखा. So section 118, the minutes of proceeding of general meeting, meeting of board of director and other meeting or resolution passed by the postal ballot. So it's talking about all those things. We are concerned only about the general meeting. So here the general meeting, subsection 2 of the section 118, that the minutes of each meeting shall contain fair and the correct summary of the proceeding. Subsection 3, all appointments made at any of meeting shall be included in the minutes of the meeting. Subsection 4, in case of meeting of the board of directors, so we are not concerned here. And subsection 1, that every company shall cause minutes of the proceeding of every general meeting of any class of the shareholder, etc. So this section 118 talk about the minutes, that minute has to be prepared. Now what would be the purpose of that minute? Section 119, that these minutes will be put at the registered office of the company, and any persons of can inspect दोज मिनट्स कि क्या मीटिंग में हुआ डिस्कशन, क्या वो फेयर समरी सारा पढ़ लेगा और क्या फाइनली उसका कंसीक्वेंस निकला। सेक्शन 119 inspection of minutes book of the general meeting. The book containing the minutes of the proceeding of any general meeting of the company or the or of a resolution passed by the postal ballot shall be kept at the registered office of the company and be open during the business hours for the inspection of any members without charge subject to reasonable instruction। ऐसा भी नहीं कि उसके पेज ही आप फाड़ दो। सो इस तरह की रीजनेबल इंस्ट्रक्शन कि आपको देखना है इस तरह से। So section 19 is about the inspection and that can be even made in the electronic form क्योंकि अभी सारा चीज़ें इलेक्ट्रॉनिक। तो section 120 also। So from 96 to 122 these are the provisions, but not every provisions whatever I have told you, only that thing you have to read and discuss. Some provision I have left because of the paucity of the time, so you have to read those provisions in the detail. Okay, and with this the today class on the general meeting is over. Thank you very much.